The Supreme Court on Monday gently drew the attention of citizens, mothers and senior citizens agitating against the Citizenship Amendment Act (CAA) and the National Register of Citizens (NRC) to the inconvenience caused when protests were held on public thoroughfares for days. A bench of Justices Sanjay Kishan Kaul and K.M. Joseph said protests could not be carried on indefinitely in a common area. On Friday, the bench indicated that the court would not be party to any sort of pre-election narrative to garner votes a day before the assembly polls. The Supreme Court, however, refused to pass any interim directions urgently in the public interest litigation filed by Advocate Amit Sahni seeking the removal of Shaheen Bagh protesters. The protests have been going on for over 50 days, you can wait. We like to hear the other side, police. Justice Kaul said. The court issued a formal notice to the Delhi police and listed the case for further hearing on February 17. The court nudged the protesters about the bother created for ordinary commuters when protests were held on public roads indefinitely. There cannot be an indefinite protest in a common area. You have to find an area for protests. If protests are held everywhere, what will happen? Justice Kaul asked Advocate Mahmood Pracha, appearing for Bhim Army Chief Chandrasekhar Azad. When Mr. Pracha submitted that there should be a balancing of rights, Justice Kaul said, this is not about any balancing of rights. Justice Joseph asked, can you block a public road? The petition filed by Mr. Sahni sought directions to the police to take action to ensure smooth traffic movement on the Kalindi Kunj Shaheen Bagh stretch, which has been closed for over a month due to anti-CAA protests, making the public at large suffer. The plea sought supervision of the situation in Shaheen Bagh, where several women are sitting on an indefinite protest, by a retired Supreme Court judge or a sitting judge of the Delhi High Court to avoid any further deterioration in the situation and to circumvent any violence. The respondents, Delhi police, cannot be permitted to behave like mute spectators, particularly in a situation presently faced by persons living in the vicinity of Kalindi Kunj, said the plea. Mr. Sahni contended that the Delhi High Court did not order the forthwith removal of traffic restrictions and observed that no direction could be issued on the methodology to handle protest and traffic movement successfully, and left it to the discretion of the police. No one can be permitted to occupy a public road for any reason whatsoever under the pretext of peaceful protest, and that too for an indefinite period to make others suffer, his plea said. The High Court had asked the police to examine the issue while bearing in mind that law and order was supposed to be maintained. The Supreme Court on Monday upheld the Scheduled Castes and the Scheduled Tribes Prevention of Atrocities Amendment Act of 2018, which nullified its own controversial March 20, 2018 judgment diluting the stringent provisions of the Dalit Protection Law. The Supreme Court had itself earlier recalled the March 20 judgment on October 1, 2019 in a review petition filed by the government. It had said it was wrong on the part of the March 20 judgment to treat all SC/ST community members as a liar or crook. It was against basic human dignity. The March 20 judgment had diluted the original 1989 legislation, saying they were using its provisions to file false criminal complaints against innocent persons. Even while reserving the case for judgment, the bench of Justices Arun Mishra, Vineet Saran and S. Ravindra Bhatt had made it clear that it would neither upset the October 1 judgment nor dilute the provisions of the statute. The government had enacted the amendments, saying the scheduled castes and scheduled tribes continued to face the same social stigma, poverty and humiliation which they had been subjected to for centuries. The 2018 Act had nullified a March 20 judgment of the Supreme Court, which allowed anticipatory bail to those booked for committing atrocities against scheduled castes and scheduled tribes members. The original 1989 Act bars anticipatory bail. The Supreme Court verdict saw a huge backlash across the country. Several died in ensuing protests and property worth crores of rupees was destroyed. The government reacted by filing a review petition in the Supreme Court and subsequently amended the 1989 Act back into its original form. Several petitions were filed challenging the 2018 Amendment Act. The lead petitioner, Advocate Prithvi Raj Chauhan, had even called the amendments a blunder and a violation of the fundamental right to equality and personal liberty. The Supreme Court, however, had refused to stay the implementation of the amendments. The government had responded that there was no decrease in the atrocities committed on members of SC/ST communities despite the laws meant to protect their civil rights. The SC/ST Prevention of Atrocities Act of 1989 is the least which the country owes to this section of the society who have been denied several civil rights since generations and have been subjected to indignities, humiliations and harassment, the government had argued. Days after former Jammu and Kashmir Chief Minister Omar Abdullah was charged under the Public Safety Act (PSA), his sister Sara Abdullah Pilot has moved the Supreme Court. The writ petition filed by Ms. Pilot on Monday was mentioned before the bench, led by Justice N.V. Ramana, which agreed to list the case for urgent hearing. In the petition, the plaintiff has invoked Article 32 of the Constitution, as there is a threat to life and liberty of Mr. Omar Abdullah, who was detained without charges from August 5, 2019, the day that the government announced amendments to Article 370. In a dossier supporting the levelling of PSA charges against him dated February 3, the government had claimed that Mr. Omar Abdullah was a threat to public security because he was planning activities against the union government, and cited his popularity and potential to draw voters to polling booths. Also read, explained, the Jammu and Kashmir Public Safety Act. The writ petition challenges the government's order, saying that it conflates governmental policy with the Indian state, suggesting that any opposition to the former constitutes a threat to the latter. This is wholly antithetical to a democratic polity and undermines the Indian constitution, it adds, appealing to the court to secure the release of Mr. Omar Abdullah from his illegal detention. Two other former J&K chief ministers, Omar Abdullah's father Farooq Abdullah and Mehbooba Mufti, have also been detained under the PSA by the government along with other leaders. Mr. Omar Abdullah had been an MP from 1998 to 2009 and subsequently a member of the J&K Legislative Assembly, the petition said. He had been a minister at the centre twice, as Minister of State for Commerce and most for the Ministry of External Affairs. It is rare that those who have served the nation as members of parliament and have always stood by the national aspirations of India, are now perceived as a threat to the state. The synopsis of the arguments to be taken up, added. Also read, extended folly, on invocation of PSA against Omar Abdullah and Mehbooba Mufti. Mr. Omar Abdullah was in preventive detention under Section 107 of the CRPC since August 5, 2019. Under the law, his detention was to end 6 months later on February 5, 2020. In charges against him, the government had cited Mr. Omar Abdullah's opposition to the centre's decision to amend Article 370 and said that he was instigating people on Twitter against the unity and integrity of the nation. However, no tweets supporting the claim had been furnished, nor had the PSA charges been shared with Mr. Omar Abdullah, the petition said. In tweets before he was detained in August, Mr. Omar Abdullah had appealed for people not to take law into their hands and to stay calm.